Welcome to everyone. Thanks for joining us on this wintry Tuesday afternoon at the end of January. We have a great program for you this afternoon, and I'm going to start it off with the COVID update that I do every other week. And as you can see, there's not much here really to report. We remain on a fairly straight line of COVID cases. The daily average as of yesterday was 3,619 cases per day. That's 19 per 100,000, about a 3% change over the past 14 days. But again, we're not seeing the significant spike in activity that we saw last January and February. Next slide, please. The color of our New York State map is good. It's yellow, it's light orange. There isn't much even solid orange to dark orange, certainly no red. Good numbers across the state. We're seeing increases. I mean, the Cortland County number is a little deceiving there, 153% increase in cases, but that's only 9 cases. So that's not a substantial increase as it relates to the general population. To go along with the current COVID data, we saw the President's announcement regarding the President of the United States announcement regarding the COVID emergency. And we will certainly be following the impacts of that announcement in the weeks and months that follow. New York State hasn't changed any of its regulations or requirements. There are no masking requirements right now. But again, we'll keep our eye on those for you as time progresses. Okay, first up today will be Arthi Chandan. Arthi is an attorney in our Buffalo office, and she is going to present to us about the recently passed Warehouse Workers Protection Act. I know there's been a lot of activity regarding this particular law, and Arthi has been on top of it. So Arthi, welcome.
Thank you so much, Adam. I appreciate it. As Adam mentioned, my name is Arthi Chandan. I am an associate at Bond's Buffalo office. I'm in the Labor and Employment Practice Group, and today I'm going to speak with you all a little bit about the Warehouse Worker Protection Act. Perfect. So just a little bit of a general overview of this legislation. It was signed into law on December 21st, 2022 by Governor Kathy Hochul. And as it stands, the law takes effect 60 days after its signing, which would be February 19th of 2023. Just a general overview of the purpose of the law. It aims to protect warehouse distribution workers at places like Amazon or UPS from undisclosed or unlawful work speed quotas, and includes protections for workers who fail to meet these quotas. There are currently proposed amendments to this legislation, which are in front of the Senate, but I'll touch on that a little bit more later in the presentation. Next slide, please. So now I'm going to get more into the specifics of this legislation. So this law requires covered employers to provide a written description of quotas to which employees are subject, and states that employees cannot be required to meet the quotas if they prevent compliance with meal or rest periods or the use of bathroom facilities. And this also includes reasonable travel time to and from those bathroom facilities. Now, under this new legislation, the definition of a covered employer is anyone who employs 100 or more employees at a single warehouse distribution center, or 500 or more employees at one or more warehouse distribution centers. Under the legislation, the term quota is defined to include any work standard which prescribes a specified productivity speed or number of tasks performed or materials handled within a defined time period. So that's kind of, the traditional definition of a quota that I think most people think of. The term quota also is defined to include any work standard where an employee's actions are categorized between the time on the task and the time off the task, and the failure to meet a task performance standard or recommendation which may result in an adverse employment action. Now, some of you may be wondering what constitutes a warehouse distribution center. So according to the text of the legislation, it's defined by the following North American Industry Classification Systems codes, or NAICS codes. These would be 493, 423, 424, 454, and 492. And if you go online and you look up those codes, they include big name companies like Amazon and UPS and FedEx, as well as some other, smaller warehouse companies. Now, if you look at the legislation, it talks a little bit about its justification. And according to the text of the legislation, the justification for it stems from the rapid growth of just-in-time logistics and same and next-day consumer package delivery, and advances in technology used for tracking employee productivity. So again, with the rise of next day delivery with UPS and Amazon, the legislature they were kind of concerned that a failure to meet these quotas could subject employees to adverse employment action and could contribute to an unsafe environment and workplace injuries. The legislature also reasoned that the warehouse and distribution center employees could potentially be deprived of the full benefit of minimum wages if the quotas are increased. Next slide, please. So to address some of the legislative concerns, the Warehouse Workers Protection Act requires covered employers to notify employees in writing of applicable quotas. It establishes certain record-keeping requirements, and it prohibits retaliation against employees who exercise their rights under the law. So just to dive a little bit deeper into those things that I just mentioned, the legislation requires that employers provide a written description of each quota to relevant employees, as well as the potential consequences of not meeting such a quota. The notices must be given upon hire or within 30 days of the effective date of this article, or within 2 business days of a quota change. The law also requires that employers keep records of quota-related data, including employees' work speed data, aggregate work speed data, and written descriptions of quotas. There are also certain employee protections. So employees are protected from exercising their rights under this law, including requesting quota-related information or filing a complaint. And there is a rebuttable presumption that if an employer takes an adverse action against an employee within 90 days of the employee exercising their rights under the law, there is the rebuttable presumption that the adverse action was unlawfully motivated. Getting a little bit into the potential implications of this legislation, it's pretty far-reaching. I think we've all noticed that over the past few years, various companies have been rapidly growing their number of warehouses in New York. And now, if a company is considering opening their first warehouse or expanding their warehouses, they must ensure that if they employ any sort of quota system, they are following this new legislation. Next slide, please. So as I mentioned earlier, Senator Ramos has introduced proposed amendments to this legislation. They have already passed in the Assembly, and they are currently before the Senate. I think today that happened. So just to start off, if the amendments are adopted, it would change the effective date of the legislation from 60 days after signing to 180 days after signing, which would bring us to around the end of May. Additionally, these proposed amendments, if adopted, they are more employer friendly. So I will highlight a few of the significant amendments and their potential impacts. So first off, the new language of the amendment would change the definition of an employee to exclude drivers or couriers to or from a warehouse distribution center. Previously, they were included as employees, but if the new amendments are adopted, they would not. Additionally, the new language expands the definition of a covered employer. So previously I had mentioned that a covered employer is anyone who employs 500 or more employees in one or more warehouse distribution center. This amendment would change it to 1,000 or more employees in one or more warehouse distribution centers. Another significant change that these amendments cover would be that employers have more time to respond to employee or former employees' requests for quota-related information. So to expand on that a little bit, under the legislation, current or former employees have the right to request a written description of each quota to which they are subjected, a copy of the most recent 90 days of their own personal work speed data, and a copy of the aggregate work speed data for similar employees at the same establishment for the same time period. So as the legislation stands now, an employer has 7 days to respond to these requests, but if the amendments are adopted, they will have 14 calendar days from the date of the request to provide this information. Additionally, under the new amendments, a former employee is only limited to one of these requests. Previously, there was no number on the amount of times they could request this information, but now they are only limited to one such request. Next slide. So yeah, that basically was, my general overview of the legislation. If you have any questions for me, feel free to ask. I don't know how much time we have, but you can always email me. I believe my email is, in the course materials. It's achandon@bsk.com, and I will do my best to get back to you with any answers.
Arthi, thank you so much. Very helpful. And I will plug Arthi's blog that she wrote for Bond's Labor and Employment blog. You can find it there, and that will have some additional details for you. Okay, next up, you got a little sneak preview, is Kristen Smith. Kristen is here to talk to us about a very significant development that affects pretty much almost all employers in New York State. So Kristen, welcome.
Thanks, Adam. Yep. So I'm here today to talk about proposed changes that the New York State Department of Labor recently released to its model sexual harassment prevention policy. If you could get to the next slide, that would be great. So as you probably know, New York State maintains a model sexual harassment policy that all employers essentially in New York are required to adopt a policy that's substantially equal or greater than. And it's hard to believe, but it's been over 4 years now. That law that required employers to have this policy and provide training passed in 2018. And the law included a provision that said that the Department of Labor was required to take another look at the policy every 4 years. And it specifically identified 2022 as the year that needed to happen. So that is what the Department of Labor did late last year. It did collect feedback. It consulted with the New York State Division of Human Rights, and on January 12th, just a couple weeks ago now, released a proposed revised model sexual harassment policy. And you can see the URL here on the screen. It did open up a comment period of 30 days to collect feedback, and so that comment period remains open until February 11th. And that gives us until next week, but would encourage you to spend some time looking at the proposal and provide feedback from an employer's perspective to the state. So we'll take a few minutes here today to go over at a high level what the changes are, but I will tell you that this is a really important topic. There are a lot of changes to the proposal. The revised policy is 3 pages longer than the existing model. And so we actually are going to offer a webinar next week, February 8th at noon, where we go into more detail. We'll spend more time than I have today. So keep an eye out for an invitation to that event. But in the meantime, I'll give you a high level overview here. If you could flip to the next slide. So basically going to cover 10 bullet points here of what's different in this proposal. One very noticeable element is a much stronger emphasis on gender identity discrimination. The new revision actually has an entire paragraph that talks about gender identity and provides definitions of the different terms that we hear when we discuss gender identity. And so, to the extent your current policy only makes a cursory reference to gender identity, it's something to consider whether you would enhance that discussion in your policy. And I should say, I mentioned it before, an employer is not required to adopt the New York State model word for word. It says that the employer must adopt it, or a policy that essentially meets the same level of protection for employees. So when I say you should consider, that's what I'm getting at here. You need to take a critical look at the model. The next section that jumped out at us when we reviewed it was an entire new section on bystander intervention. It has its own heading and discusses the different ways that someone who witnesses potential harassment can intervene to either minimize or put an end to the harassment. One notable example that the state puts forward is telling employees that it should record observed harassment for use in a future in a future investigation. That certainly caught our attention. It's not typical practice that employers encourage their employees to record interactions in the workplace, so we want to take a critical look at whether that's something we wanted to include or not. Another change is a broadened sort of reference to discrimination generally. So this law is focused on sexual harassment specifically, and so the policy itself really is just a sexual harassment policy. We know that as an employer, we should prohibit discrimination and harassment and retaliation very broadly. And so, we encourage you to have policies that don't just address sexual harassment, but other forms of harassment as well, discrimination, et cetera. This policy seems to recognize this more. It's still primarily about sexual harassment, but it includes the word discrimination that wasn't in it before. It talks about how there can be an intersection between gender-based harassment and other types of harassment. Another change is that it focuses on New York's broader definition of workplace harassment. So when the original model came out, where it was 2018, and this was actually before the state passed an amendment to the human rights law that lowered the standard for what constitutes unlawful harassment. It used to be, really quickly here, used to be that in order to be unlawful, harassment had to be severe or pervasive. The new standard is different than that. And the new model policy really goes into depth about that. The standard now being that the conduct needs to be more than a petty slight or trivial inconvenience goes into depth about that. So I would note that it would be important for you to take a second look at your existing policy and make sure you're not making references to a legal standard that's not in effect anymore. Another change in the new model is a much stronger emphasis on supervisory responsibility. The law specifically calls out that in any policy you maintain, you have to point out supervisors' responsibilities. This one just takes it a little further, emphasizes it more, adds more language to underscore that point. So in terms of this change, it's a matter of degree, not of substance. Go to the next slide, please. The policy also adds a number of examples, and I think all would agree that including practical advice in a policy is a good idea. It helps employees to understand the types of conduct that they should, be avoiding or reporting. And so additional examples are a good thing. The prior model did not have specific examples of retaliatory acts, and now it does. And those would range in the policy from the obvious adverse action of terminating an employee or demoting an employee, all the way down to more minor acts like changing the location of their office. And, I think that's where you need to take a critical look at the model to determine, which of those you would want to include. Because it's sort of questionable whether that very minor act of moving an office would always be considered retaliation. Speaking of examples, the policy gives a number of more detailed harassment examples as well. So a good idea to take a look at those. Also a sign of the times is its reference to remote work. Again, that 2018, not really a big topic. Today, the world is different. Many more employees are working remotely. So there is specific reference to ways in which an employee might engage in harassment in a remote work setting, specifically, misusing the chat function in a video conference. That comments that are made of a harassing nature in that setting could be considered workplace harassment. And so that's probably, if you have a workforce that does have a component of employees who work remotely, it's a good idea to consider adding that. Another change is the inclusion of the new sexual harassment prevention hotline. I'm confident that we've covered this new development in the law in this webinar in previous occasions and in various presentations. But briefly, there's a new law that created this hotline that employees can call to determine if, you know, the conduct they're experiencing at work does rise to the level of harassment, and you are now required to put that in your policy. Finally, I noticed a greater emphasis on external reporting options, and this is just a matter of how the policy is arranged. In the previous model, it's the last thing in the policy. It's on the last page, you know, how to contact the EEOC or the Division of Human Rights. Notably, the new model puts it on page 1. You know, so certainly wanting that this is the Department of Labor and the Division of Human Rights, making employees wanting employees to be aware of these external options from the very start. So I know I just flew through those changes. Those aren't all the changes. Those are the ones that stood out to us. We are going to be delving into this much more deeply next week at our webinar on February 8th. And again, take a critical look at this. The other thing I just want to remind you is that this is still the proposed revision. And so after the comment period closes on February 11th, we will keep an eye out for when the final model comes out, and we will certainly let all of you know that when that occurs. Thanks.
Kristen, thank you so much. And thank you for providing us with that overview. I would encourage everyone to attend the pop-up webinar that Kristen is going to be doing next Wednesday. I know I will be there. These are very important issues for employers. So thank you, Kristen. Okay, next up, we have Frank Mayer. Frank has been on before. Frank is a tax attorney in our Albany office, and consistent with our theme of looking forward to 2023, Frank is going to be talking about legal issues related to the employment of out-of-state telecommuting workers. Frank, welcome back.
Thank you, everyone, for being here today. I was delighted when Adam asked me to actually talk about tax. So I know many of you have employees or want to hire employees that work out of state. And, you know, the general common sense thing is, well, what difference does it make where you work? Well, unfortunately, to many state governments, it does. So I'm going to run through a couple of things. I'm going to talk a little bit about the employer registration requirements out of state and some other things that we might not necessarily think of, like that would go along with an employer registration when you have a remote telecommuter. You know, business administration, income taxes. I mean, not just employer withholding, but income taxes for the company in the case of a for-profit entity, sales taxes and applicable exemptions for organizations like tax-exempt organizations, and New York State withholding issues. And if we have a couple of minutes, we'll touch on employees working abroad, because I know we get many inquiries about that now, which adds an extra layer of interesting issues to deal with when that happens. So I'm going to give you a couple takeaways today. And if you take nothing from what I'm talking about, just take these two things away with you. And here's the first one. So wages that you pay to an employee are subject to taxation in the jurisdiction where the services are performed. If you're a New York-based employer and you have an employee working in North Carolina or Pennsylvania, that person is subject to taxation in that state. The state takes the position that that employee avails himself of that forum, the roads and the services. So that's where that state believes the employee should pay their taxes. So given that, employers need to typically register as an employer for income tax withholding. They need to provide unemployment insurance in the local jurisdiction. Even if you're a New York employer and you have New York unemployment insurance, you likely need to register for unemployment insurance in that jurisdiction. Some states have de minimis thresholds for unemployment insurance. Maybe it's, if you pay more than $500 of wages in the quarter, you have to have unemployment insurance, or if you have, more than one employee in some cases, but it varies state by state. The employer also needs to provide, typically workers' compensation in the jurisdiction where the telecommuter is working, as well as any other lawfully required employee benefits. So New York PFL, paid family leave, wouldn't apply to that employee working in Pennsylvania. If PFL is required for employees working in Pennsylvania, the New York employer, for example, would need to provide that employee with New York PFL or required breaks or vacations or whatever is required under that particular jurisdiction. So the second takeaway is employment laws of the local jurisdiction apply. So the two important takeaways here: wages are subject to tax in the jurisdiction where the services are performed, and two, the employment laws of the jurisdiction where the person is working, not where the employer is situated, are what apply to that employee situation. So employers sometimes find themselves with the need to have, multiple appendixes to their employment employee handbook. So the second thing that an employer needs to deal with after they register as an employer, and typically that can be done online with one application, and you can hit withholding, unemployment insurance, workers' comp, and any other required benefits in one application, is business registration for things like corporate income tax and sales tax. Now, if you're not for profit, you'll say, well, this doesn't apply to me, which is true to an extent, but you still may need to file for an exemption. So having an employee in the state performing services, even if that employee is performing services for New York clients or customers, may still subject the organization to corporate income tax. The good news, may require filing of income tax return, but the good news is the employer may be able to apportion some of its income away from New York and towards the other jurisdiction, which with any luck might have a lower tax rate. So it doesn't mean that the employer would pay more corporate income tax. It just means that they might have an additional compliance burden to reapportion income from New York to that other jurisdiction. And again, as I mentioned, tax exempt entities may need to file for an exemption from corporate income tax. And however, tax exempt entities may need to file a form for unemployment insurance. I should say unrelated business taxable income, the UBIT. So if they have any UBIT, unrelated business income in that state, they would need to report it in that state and pay the tax. And again, in-state registration as an employer would also potentially create sales tax nexus, but typically the organizations, wouldn't necessarily, if they're not selling any products in the state through that employee, probably not going to be an issue, or selling products in that state. Another thing to mention is that licensed professionals. So if you're, a psychology counseling service or a medical practice or an accounting firm, and you have employees in another state, be it, Connecticut, Pennsylvania, those employees, maybe they used to come over the border to New York and work for the day. If they're working from their kitchen table in that state, they need to be suitably licensed as a professional in that state, even if they're doing Zoom calls with New York clients or working on matters for New York clients at their kitchen table, preparing spreadsheets and so forth. So again, need to be licensed as a professional in the state to the extent the organization requires professional licensing. Another thing that employers need to be concerned about is the qualification to do business. So usually we think about, being employed in the state, think, well, what does qualification to do business have to do with me? I just have an employee working, at home in their pajamas. Well, states sometimes see it that if you have an employee working at home, even if they're not interacting with other customers, that you may need to qualify to do business in that state. That's not filed with the state tax department. That's a filing made with the local Department of State. Here we call it the New York Department of State. Every state has its own name for the organization, but typically that was something that would be done. And failure to qualify to do business can cause problems for the organization because it may prevent the organization from bringing a lawsuit in that state, but typically companies can defend themselves. Most states have penalties for foreign corporations or businesses that transact business in the state without being registered in the state. So the definition of transacting business, though, is a little problematic. Typically, states will provide you qualification laws that provide only negative assurance. And they'll say maybe the following 4 or 5 things don't constitute transacting business. For example, having a bank account in the state, having a registered agent in the state to prepare stock transfers, book account transfers, things like that, holding directors' meetings in the state, but they don't tell you what constitutes doing business. They let you figure that out. And if you're lucky, maybe you can find a case that addresses it, or a tax department or state department information memo on what the state's position is. But usually that's the exception rather than the rule. So out of abundance of caution, most employers who have employees working remotely also register to do business in the state. And finally, if that's not enough incentive, some states impose penalties individually on officers and directors of non-compliant foreign organizations. So if you're in a management position, you might want to make double sure that the organization is appropriately registered in the jurisdiction where you have your telecommuter, in order to avoid any concerns about personal penalties, to say nothing about penalties for the organization. Now, finally, because we're in New York, or most of us are anyway, well, New York takes this telecommuting thing to the next level with what it's called its New York convenience rule. And being New Yorkers, New York is one of only 4 states which has this convenience of the employer rule, which says that if you work out of state for your own convenience, rather than out of the necessity of the employer, then that employee is subject to taxation on all of their income, even though they work out of state. So what that would mean is that the employee would, let's say, pay North Carolina income tax, you'd withhold that. But because they work for a New York employer, and maybe they come back once a month, or once every 3 months to the office, New York will say, okay, every day that you're out of state for your own convenience, as opposed to necessity for us, you're subject to tax in New York. And so New York wants its own share of the tax. So not a prorated amount, but 100% of the tax. And that's been the case of the tax department's position since January 1st, 2006, based on a New York Court of Appeals case called Huckabee, the Court of Appeals being the highest court of the land in New York State. Basically, Mr. Huckabee was an IT person who worked in Tennessee, spent 40% of his time in New York. Interestingly, Tennessee had no state income tax at the time, but that's not germane for the court's reasoning. Basically, that said Huckabee was in Tennessee for his own convenience, not out of necessity of the employer. So Mr. Huckabee ended up paying tax on 100% of his new income, even though he was there 40% of the time in New York. Now, the court specifically said that we're going to stop short of ruling on what the minimum level of contact is with New York for creating nexus with New York for withholding. And, is it 40%? Is it 10 days? Is it 1 day? If you're in New York state 1 day, does it create nexus? Most commentators say yes. The question is, what about someone who's not in New York at all? And the answer to that is a question mark, because there's no case out there that addresses a telecommuter who never came into New York during the year and is subject, and are they subject to tax? Can New York get jurisdiction over that person? So what employers typically do out of an abundance of caution is to withhold the New York convenience rule tax on its telecommuters, and then let the telecommuters themselves work with their own tax advisors to seek a refund of that tax. So, if the person, for example, came home and worked a Thanksgiving a couple of days that week, and the employer didn't know it, then surely the employer could be on the hook for the withholding that they didn't make. So because nobody really quite knows where their employees are all the time, employers are generally advised to go ahead and withhold the tax, even though their employees may never come into New York State during a given course of a year. So what are the factors that make an employee's work out of state a necessity rather than the employee's own convenience? Well, the New York State has published a TSBM. I'd be happy to send it to anyone who's interested. In 2006, which is still good authority, they list a primary factor saying that, if you're there near specialized facilities, then the New York State understands that, and you're not subject to this convenience rule tax. They cite an example of an engineer who tests new cars. There's no test track or racetrack at the corporate offices in New York City, but there is one near the engineer's home in Michigan. So as a result, that employee would not be subject to the New York convenience rule because they meet that critical factor. But most people don't fall into that category. So they have a set of secondary factors and incidental factors. In the secondary factors, you have to meet 4 of the 6 of the secondary factors, basically saying that if you meet 4 of the 6 of the secondary factors and 3 out of the 10 of the ancillary factors, you would not be subject to the convenience rule. But from experience doing this for more than 15 years with this policy, I've yet to see an employer that can overcome this. To give you a flavor for this, the secondary factors of which you have to meet 4 of 6 include things like the home office is required as a condition of employment. I suppose you could write that into an employment agreement if you had to. The employer is working. Second would be employers are working on projects with deadlines that are out of state. So for example, an engineer working on construction projects that needs to be there to work on these projects. That would be a factor if you can meet that requirement. The third one would be the employee performs core duties at the employee's home, which this could be done. For example, a stockbroker executes trades at the employee's home, but for example, it wouldn't be met if the stock broker just read periodicals on the weekend about investing. Another factor of the 4th of the 6th factor was that the employee meets or deals and meets physically with clients at their location. You can tell this is an old policy because how many people meet physically today? But that's the requirement that the person requires, their duties required to meet physically with clients, patients, or customers at the home. Another factor, the 5th factor, would be that the employer doesn't provide designated office space because maybe they downsized and there's no space in the office in New York. And when the employee comes in, they have to use a visitor's cubicle. If you could meet that requirement, that would be a helpful factor. And 6 would be the employer reimburses the employee for substantially all of the employee's expenses of the home office, and all means substantially all, so 80% or more. So you can see it's hard to get 4 of those 6, and then you've got to get 3 of another 10. And I'll just run through a few of them because I know we're running through time here pretty quickly. You got to have a separate telephone line, but again, it's an old policy. So who has that? You've got to have separate letterhead or business cards of the employer noting the employee's home office on it. Other factors include the specific area of the home used exclusively to conduct business. And so I don't know about the rest of you, but in my home, nothing is specific, because kids' toys are left all over the place. And, home office space usually doubles up as the home gym or the guest room or something else. So that can be a little tricky. And then other things of the 10, the employer is not an officer of the company. The person claims a deduction for home office expenses, which of course, under the Tax Cuts and Jobs Act, nobody can deduct anymore, at least until 2026. The home is covered by a business insurance policy and other factors. So you can see these make it difficult to meet that requirement. So typically employers end up withholding taxes for both New York and out of state. And I was going to allocate a little time for talking about foreign employment, but I know we're probably running short on time here. So, it's great to be able to choose from a large talent pool of employees from, out of state or even out of country, but there are challenges and compliance costs in doing that. And, certainly if anyone has any question or is contemplating hiring an employee out of state or wants to deal with one of those situations where we know we have somebody out of state, but we've kind of looked the other way about it, and now we think we need to address it. I can certainly help you with that. I'm one of those people that picks up his phone when it rings. So I'd be happy to talk to anyone, or if you'd like to reach out, I can be reached at fmayer, F as in Frank, MAYER at bsk.com. That's fmayer at bsk.com. And I'd like to thank everyone for listening today.
Frank, thanks so much. And there's always more time, Frank. You can just come on again to talk about foreign employment. So thank you for the great summary. Frank's contact information will be at the end of this presentation. Okay, last, and as I usually say, not least, it's me to talk to you about the New York healthcare worker vaccine mandate and what's going on with it. So let's start off. Next slide, Kathy. I'll be brief here. A little history. So in August of 2021, the New York State Department of Health promulgated the emergency regulation we've known as the New York State Healthcare Vaccine Mandate. This required healthcare entities to continuously ensure that their personnel were fully vaccinated against COVID. Now, the important thing about the New York State vaccine mandate was that it provided for limited medical exemptions, but it did not provide for any religious exemptions. There were multiple challenges in state and federal courts very shortly after this emergency regulation was promulgated. Next slide. And those court cases were ultimately decided by the Second Circuit Court of Appeals, who resolved the issue related to the regulation's lack of a religious exemption in its November 2021 We the Patriots decisions. There's actually two decisions, but essentially what the Court of Appeals, Second Circuit Court of Appeals held was that the vaccine mandate was lawful, even though it didn't provide for religious exemptions, and that employers could not grant religious exemptions that would permit employees to continue working unvaccinated in positions where they could potentially expose others to the virus. So we had a flurry of activity immediately after this regulation was promulgated in August, which culminated in November with the Second Circuit Court of Appeals decisions. At that point, it seemed clear that this regulation was in place. Healthcare employers had to follow it, and everything was fairly quiet. Next slide. Until just recently. So in June of 2022, the DOH commissioner permanently adopted the regulation. The initial regulation in August of 2021 was an emergency regulation. In June of 2022, the DOH commissioner made that permanent. We then didn't hear anything again for several months until just a couple of weeks ago, we got two very relevant decisions related to this vaccine mandate. The first came out on January 10th from Albany County Supreme Court, and the second came out on January 13th, just 3 days later, from Onondaga County Supreme Court. Before I get into this a little more, I think it's helpful to understand how New York's court system works. So we, in our state court system, we have trial level courts, which for some reason we call Supreme Courts. We then have an intermediate appellate level, and then we have one court of appeals, which is the highest appeals court in New York State. These two decisions came from trial level Supreme Courts, one in Albany County, one in Onondaga County. They reached completely opposite conclusions. The Albany County judge held that the Department of Health had sufficient authority to promulgate the vaccine mandate for healthcare employers. The Onondaga County Supreme Court judge said that they didn't. So really, they're diametrically opposed decisions, reaching entirely opposite conclusions. The Onondaga County Supreme Court judge held that based upon his decision, the regulation was invalid and the Department of Health was prohibited from implementing or enforcing the regulation. So what happened? Next slide, please. Right now, there is no appeal of the Albany County litigation, Albany County decision, I should say, but the State Department of Health filed a notice of appeal relating to the Onondaga County Court decision on January 24th. And then they filed a motion to the appellate division, that intermediate appellate level, for a stay of the judge's order pending the appeal. That motion was filed last Friday, and it's scheduled to be heard on February 6th. So, next slide. Where are we? And I know this is a question that healthcare employers are struggling with right now. Well, first of all, don't forget that in addition to the state vaccine mandate, there's also a CMS vaccine mandate. It has a similar requirement that healthcare employers ensure vaccination of their employees. However, and this is a big however, the CMS mandate allows for both medical and religious exemptions, unlike the state mandate. So, whereas the state mandate doesn't allow religious exemptions to keep employees working in person and with patients while not vaccinated, CMS does. Where are we with the New York State healthcare vaccine mandate? Well, we have to wait and see what the appellate division says after next Monday's argument on the state's motion to stay. So we're kind of in a holding pattern on the state mandate, and we will certainly keep you updated as we get any new information on that. So with that, we are done for the day. Thank you all for attending. We look forward to seeing you next week. If you have any questions, here's the contact information for everyone who presented. Please feel free to reach out. Thank you. We'll see you next week.